The YSL trial is the case that keeps on giving. Welcome back to the channel, and we're gonna get a little ratchet, a little ghetto today. And if that's not your speed, go ahead and keep scrolling. Go watch the next video, because today we're getting straight ghetto and gutter. Not really, but if you've been following the YSL trial, lean in for me for a second. Why you ain't tell me they play lifestyle in court? Show, I'm sorry, can I say show? YouTube, please don't ban me. The trial has been a show. And so let's dive right in. But what I want to talk about today is the use of rap lyrics in trial. So apparently there was a section in the YSL trial that I missed. What's funny is I actually recorded this video once before, but the video was so trash that I am re-recording it again now. So hopefully, please let this video hit, because y'all, I'm trying. I'm on my YouTube journey, so bear with me. But apparently the judge played lifestyle in court, which obviously sounds hilarious to me. If the Boondocks was still on TV, the Boondocks would be having a field day with this case, because it's absolutely ridiculous. It's like something that you would see on SNL. So I want to play the video of the court listening to lifestyle in court, get into the arguments that they're making, talk about that, have some commentary, and maybe we'll learn a little something new, or maybe we won't, and maybe we'll just continue to see that this trial seems like a clown. So let's get started. Child, all right, let the shit show begin.
Judge, there was one matter that Mr. Steele brought to our attention. I don't know if he intends to.
What is it?
He had intended to introduce a video. I don't know if he intends to do that today, but if he does, it's a matter that would probably be best to argue it outside the presence of the jury. He served it on us this morning that he intended to do that. So
how long is that video?
It's 4 minutes, maybe.
Okay, have you all looked at it?
Yes, we've looked at it. We contend that it is inadmissible through Mr. Stevens by Mr. Steele under 24-801 D2A. It's his client's video. It's outside the presence of the jury. He served it on us this morning that he intended to do that. So
okay. Long story short, let's take a pause right here. Already getting into it. Yes, we love a legal explanation and a quote. So essentially what the prosecutor is arguing here is that Mr. Steele, the defense attorney for Young Thug, served a video on the prosecution that morning saying that he intended to introduce that video in court. The prosecution at which point wanted to take up the question as to whether that video should be admitted into court, but they want to take up this issue outside the presence of the jury. This is pretty common. The prosecution and the defense attorneys will take up matters outside the presence of the jury so as to not prejudice the jury against their respective interests. So in this case, there's a video, which we already know is going to be lifestyle. What the state is alleging here and what they're arguing is that the song should not be admissible the way that Mr. Steele wants it to get admitted. So Mr. Steele wants to get that video admitted by somebody who, from my recollection of the case, is not in the song, is not a rapper in the song, is not a writer in the song, is some third party who knows about the song but can't really testify, but can't really create a nexus, can't really testify as to how the song was written, what they were doing when they wrote the song, when they performed the music video. As far as I understand, this person was not involved at all in that creative process. And the state is saying that they do not believe that this third party, this person who's not involved in the creative process, should be able to get that video in, or that the video shouldn't be admissible through that person, meaning that person should not be able to testify regarding the video. So that's a little bit of the back and forth that we've heard here, but I know that the judge and the prosecutor and the defense attorneys will flesh that out as the case continues.
Yes.
One second.
Sorry, y'all. I gotta speed it up because there's a lot of just dead space and like nothing going on. So 1.25 speed it is.
Anything happened yesterday? Why did you get link? Is there a link for him?
I don't know why they're doing it on Young. The cameramen have been very shady this entire trial. I like that t-shirt though. Get to it.
All right, Mr. Steele, are you trying to show this video today?
Sure.
Thank you. Let's mark it, and can we pull it up so I can look at it? What exhibit are you going to mark it as, Mr. Steele?
Your Honor, that will be number 32, Mr. Wood, 32, and fast, Mr. Cook.
If he's faster today, okay? Because I'm really kind of annoyed with his slowness pulling up these videos. I'm just teasing. All right, Mr. Cockwell, can you pull it up? Okay. No pressure.
So the judge just kind of made a joke there, like, oh, I guess whoever's pulling up the videos has been taking too long to pull up the videos. So he was like, oh, be faster today because I'm frustrated with him pulling up the videos, taking so long to pull up the videos. Just kidding. The joke clearly did not land, but that was a joke that the judge was making.
Hold on 1 second, Mr. Coco. I need to get my. Okay, 1 second.
Oh my God, this is about to be so ghetto. Like, why are they playing this song in court? I feel like the judge could have simply listened to this outside of court. I don't understand why he. Oh my God, it's crazy. Look how slow this is moving. I have it on 1.25 speed and still listen to all the nothingness that's happening. Like, just so much dead space and time that's just not being used effectively in court. Like, they could have already had the video pulled up and ready to go. Now we're just sitting here.
Defendant Williams 32, is that correct, Mr. Steele?
Correct, Your Honor.
All right, Mr. Kokomo, go ahead and play, sir.
Oh, why is that?
Got like 4 hours in the 20. Did a lot of shit just to live this here lifestyle. Came straight from the bottom to the top of my lifestyle.
Look at this man. This man, like, I'm not gonna blink, I'm not gonna smile, I'm not gonna laugh, I'm not gonna move. I'm just gonna sit here quietly and look real serious. Okay, with the freaking suit on. The sweater. Not the naughty. Okay, come on, blue glasses. The head naughty.
I'm the best color, lots of fucking guys. Been serving great white like I'm feeding shop. I won't do nothing with the bitch, he can't even get me high. I'm all around with the pussy. Even though I ain't gonna hit it, I'ma still make sure that she good shit.
Wow, I never thought we would be hearing the word punani, P-U-S-S-Y, in open court and listening to rap songs that have been played in a club that I might have or might have not participated in hoodlum activities to in the club at one point when I was younger. Now I'm old, I'm grown, I'm mature, you know what I'm saying? I'm a lady, but I mean, there was a past at one point. Anyway, back to the song.
We ain't got time to go see
They know they want to dance so bad. That man covered his head. I know that's right. I too don't know why we're doing this or listening to this right now. The ghetto.
I'm on a random bands, I'll take out a fun bitch. I got a mom's bitch, she got a mom's bitch. I got sisters and brothers to feed. They ain't going out like no idiot. I'm a did a lot of shit just to live this here life.
I feel like he was trying not to nod his head. You know he want to dance. He want to rap. He probably know the whole song. I know he's going to get up and rap his little part. If he's even on the song.
I'm on top of the mountain, puffing on clouds and niggas still That's for the hood side. Fuck nigga. I'm a ride for my nigga. Hey, corn boy.
Already.
Ride for my nigga. Hey, corn boy.
I'm about to see this song. Once it comes up. Not the who is singing. Come on, Ty. My man in the back, this man right here, jamming. That's his favorite song. He definitely knows every lyric.
God told me they can never stop me, so they ain't gon' stop me. I'm in that comment with baby mommy get sloppy. I'm bleeding red like a devil. I see these bitches plotting. They wanna know how I got ill and I didn't finish
This song is old, but it's still good. And I'm over it. speeding it right along. I'm over it.
My daddy beat on my shit. Happy up like a
Can't take it.
Did a lot of shit, just got to the top of my line.
Just top to be near the end.
Swagged out.
What's wrong with hell? Okay. I don't understand why we just sat there and listened to that. We should listen to that before. Please don't play it again.
One time's enough, Mr. Kokomo.
Thank you.
All right. Okay. All right. So, Mr. Steele, you want me to admit this, and what's the reason? I suppose you're gonna lay a foundation through Mr. Stevens.
So right now we're talking about foundation. You're always going to have to lay a foundation through a witness. So you're going to have the basis of foundation is, how does this witness know anything about whatever it is you're trying to get into the case? So if these are rap lyrics, how does this witness know anything about these rap lyrics? Did the witness write the lyrics? Was the witness involved when the lyrics were produced? Was he involved in the music video? What does he know about these lyrics besides what everybody else knows, which is, I heard the song on the radio and I streamed it on Spotify once, a million years ago. You're gonna have to give us a little something tighter than that, because if that were the case, then pretty much anybody, like, they could call me into court and have me testify to this song. Of course, I've heard it before, but does that mean I have any foundational, what knowledge, what information do I have regarding these rap lyrics?
Good morning, sir. And yes, that is true. And then, assuming that foundation is laid to the Honorable Court's satisfaction, and the court admits it, there are three things that are pertinent to this video. You will look, if you don't mind, or may remember, in overt act number 14 of count 1. You will see a photograph that the grand jury attached to that charge, and it's Mr. Williams along with Mr. Copeland. It's a Instagram posting, allegedly with Mr. Williams' Instagram handle, and they're wearing shirts that you see in this video. The shirts are RG, and RG, it would, my contention, stands for Rich Gang. And Rich Gang, we're here with, an allegation of a criminal street gang. And I want the jurors, I think I'm entitled, I would like to show the jurors what Rich Gang is. That is their music.
Here we go. Simple. So the prosecution is alleging that Jeffrey Williams, along with other individuals, other associates, are in a gang, RG, and the defense attorneys are saying that's not a gang, that's just the name of their music group, Rich Group, or whatever he said, Rich Gang. I can't remember what he said, but it's just, that's the name of their music group. That's not a name of a gang. So they are contesting this allegation by the prosecution that the client is in a gang. So that's exactly what the RG, when you see the RG on the shirts, he's going to use that to say that's their music group. He's going to ask the individual on the stand, what does RG stand for? The individual on the stand is going to say that stands for our music group. It's not a gang. So that is what the defense attorney is arguing here.
Compilation number 2. There is a lot of red being worn in the video that has been just played for the Honorable Court, which I believe is number 31. If I'm wrong, it's 32. 32. Okay, thank you. And Mr. Williams is not wearing red in the video. It is being worn by other people. The third reason, Your Honor, is there are 2 witnesses on the state's witness list.
Okay, so let's break down that second allegation. So he's saying one of the state's contention again is that red is the color of the gang, but in the video you can see that his client is not wearing red. So even if the red is a color to be associated with the gang, even if that's true, and I don't think the defense attorney is even conceding that's true, but even if that is true, my client is not wearing red, so my client is not in any sort of gang and is not affiliated with the gang in this particular video. So that's argument number 2.
Mr. Brian Williams, his performing name is Birdman, and Mr. Of course I can't remember, it's Lamar, I can't remember his first name.
The Qantas Lamar?
Thank you, I apologize.
Okay.
Also,
right.
A performer known as Rich Homikwan, or RHQ. He's in that video. He's a performer. It will explain Mr. Williams' relationship with them. And this is not a statement as in OCGA section 24-8-801D2A, as in Lisa and Alpha, because I am not looking for this statement or these words of Mr. Williams. He is singing. there are lyrics of Mr. Williams that he is singing on this video, but these words are not for the indictment. This was also made in 2012 or 13.
This video?
Yes, I have to check my notes.
All right, got all that. Why do you think that?
Okay, so let's go back. So he's essentially saying that the video is not hearsay because he's not admitting the video for the truth of the matter asserted from what his client is saying in the video, right? Because this whole contention, the defense attorney, the whole argument is that my client is a rapper. The rap lyrics don't reflect my client's real life. He might rap about things that are true, but he might rap about things that are not true. You know, people just they cap. They flex. They say all types of stuff to look like they're living a certain lifestyle. That doesn't mean it's true. It's just a rap lyric. It's art. So he's saying he's not admitting the video for anything that the client is saying or indicating in the song or in the video. He's just admitting the video, number one, to show his client's not wearing red. To number two, show that RG means rich gang. And those are the two main reasons that he's getting the video. He wants the video to come into evidence. So those are all admissible reasons and excellent reasons to have this video admitted. The question then becomes, can he get the video admitted through the witness he wants to get the video admitted through? And here it sounds like the judge is already having some reservations. As you heard the judge say, the judge said, got all that. I understand why you want to get the video in. You want to show your client's not in the gang, all that good stuff. Great. Who is going to get on the stand and testify? Not your client, right? Because your client has the right to remain silent, doesn't have to testify if he doesn't want to, probably doesn't want to with all these allegations. So you're going to have to get the video in through somebody else who's willing to testify. And that's what we need to listen in on here.
Mr. Stevens would be a better witness for foundation rather than either Birdman or Mr. Williams or Mr. Lamar, Rich Homie Quan. If they're in the video and if they're going to be called, why wouldn't it be better to lay a foundation for them?
Two reasons. First of all,
so he's saying that there are two people that are actually in the video that are going to be called as witnesses. They may or may not be, but it sounds like they likely are. And the judge is saying, well, why are you going to call somebody to the stand to talk about this video, a person that's not even in the video? Why wouldn't you get the video in and have somebody who was actually in the video to talk about the video? So that's the big hump that the attorney is facing.
I believe that Mr. Stevens can. This is a public domain.
It doesn't make a difference if it's public or not. You still have to have some basis of like frame of reference to then kind of just lay the foundation from that. You still have to kind of orient it as to place and space. And I'm not saying that it's not admissible. It's just, I don't think that unless he has some nexus with that. I mean, then we'd be up here all the time and you just be showing people, oh, did you understand this? Or does this?
Yeah, I mean, that's a big problem. So what the judge is getting at here is the defense attorney said, well, the video was in the public domain. Okay. What the judge is saying is that doesn't make a difference, because if that were the standard, then anybody could testify about anything. We'd be up here all day, as the judge said, just anybody who's heard this song and listened to the song in the public domain, come up here and testify about the song. That doesn't make sense. You got to have some connection to the song, the video, something like that. Something deeper than just I heard it because it's in the public domain.
The person that we're looking at, you've got to have context. And if he can't provide context, he's not the best person to probably lay the foundation for that. I mean, he can state the obvious, but he's got no context. Much like, or different like if you have Mr. Williams or Mr. Lamar come in and they say, okay, well, listen, yeah, I'm in the video, and let me tell you, in 2012 or 13 with the foundation, this is what was going on, and here's why we're singing about rich guy. You see the difference?
No.
Well, okay. We'll have to disagree professionally on that one.
I'm not trying to disagree.
No. Look,
you're asking me a question.
I'm asking you a question, but I'm also telling you why I would probably sustain the state's objection. At this point, I think it.
So the defense attorney that was saying no, he just doesn't agree. He doesn't understand why the person he wants to get the video in through, even though that person wasn't involved in the video, he doesn't understand why that person can't talk about the context of the song, and why he can't get up there and testify. The judge is saying because he just has no context, he wasn't there, he wasn't involved in the video, why would he be testifying about the video? That's the back and forth that we're listening to here.
From the court's perspective, it's admissible. It's just not admissible through him.
Right.
Well, I'm going to then.
From the court's perspective, it's admissible, just not admissible through the witness that Brian still wants to get it in through. Exactly.
Ask the court to reconsider for two issues. First of all, and I know every ruling is different. I'm aware of that. But the Pushing P video that is directly in the indictment, Mr. Stevens did not have any type of nexus to this,
and it was objected to. And I'm telling you, I'm telling you why I as the gatekeeper are not going to continue on that line of introduction.
Then I don't want to.
So it sounds like the defense attorney is about to say, okay, well, we literally just had a previous situation almost exactly like this, if not exactly like this, and you let that person testify. So I don't understand why you're not keeping that same energy right now.
Raise a frivolous motion?
No.
That is the gatekeeper that you are going to do, and that the gate's not opening up right now.
Yeah, I mean, I'm just telling you. Again, I think the evidence is relevant and it's admissible for the reasons you just told me. Now, I understand that, this is the state's case in chief, and you're trying to get out what you need. He's just not the witness to do so.
Well, I also like in the court to, when I make the motion, I'm making it now, then any of the state's witnesses who are going to talk about lyrics, going to talk about videos, going to talk about photographs, they have no nexus. They are just pulling things off the internet that's in the public domain. And then if this honorable court just adopts this, or not adopts, if it enforces this ruling, then I'm making a motion to exclude that evidence.
I rule on what's in front of me.
So the defense attorney, Mr. Steele, is saying, listen, the state's witnesses, he has reason to believe, or maybe he's already seen this, are simply testifying based upon things they've seen on TV, seen in the public domain, testifying about things they don't have any knowledge, or they can't add any specific context to. They don't have any nexus, rather. That's the word I'm looking for. Nexus, context. They don't know anything outside of what they've seen either on TV or what they've heard on the radio or that they played on their Spotify account. So if the state is allowed to have those witnesses do that, then I need to be able to do it too, or you need to enforce the rule the same for everybody. Everybody needs to not have any witnesses that are going to testify to things just because they heard the songs in the public domain. And the judge is saying, okay, I'm not about to make a blanket ruling right now. I'm going to tell you that I'm going to rule based on what's in front of me. Right now, what's in front of me is this situation with this witness. You want to get on the stand and testify about the video, and it ain't happening. It's not happening right now with that witness.
Okay, it's disingenuous for you to say that. Okay, I look at what is presented before me. I try and get it right for both sides. I am not admitting or excluding evidence in a vacuum. So for you to say that is disingenuous to the court. I'm going to look at the evidence depending upon the facts and circumstances of what I have before me. If the state has an issue with foundation, I'm gonna hold them accountable as well. And remember what I told you about the lyrics and everything else. It is dependent upon what is presented in terms of a foundation, and I believe I made that very clear when we argued that motion with Mr. Carlson.
So you heard the judge say there, it's disingenuous for you to say that to make it seem like I'm not being even or equal across the board, or that I'm letting the state do things that I'm not letting you do. He's saying that's not true. I rule as it comes along. And if the state has foundational issues, then they have foundational issues, and the objection against the state will be sustained. If you have foundational issues, then your evidence is not going to get in. I'm going to keep the same energy all around, but don't make it seem like I'm favoring one side or the other. That is what the judge was saying, in so many words there. Maybe I did spice it up a little bit, but that's the gist of what he was saying.
I'm just telling you, I believe your evidence is for a proper purpose. I just don't believe that Mr. Stevens is the right person at this time for the reasons that I've just stated. He provides no. Part of it is you have to understand. You have to know what you have to know, or have some relevant basis to testify about what's in the video, or what's in the item, what's in the picture. Mr. Stevens struggled with that yesterday. He really did, and that's the court's concern. Madam, did you have something you want to say?
I do, Your Honor. Additionally, Your Honor, the requirement of Rule 801 D2A that an admission, and it does not have to be inculpatory or exculpatory, but that it be offered against a party is designed to exclude the introduction of self-serving statements by the party making them. So the state's contention is that if Mr. Williams wants to put in words spoken by Mr. Williams will have to take a stand, and he can get that in, and that he would be the proper person to get in his statements through, not someone else. That is the reason that we are objecting.
As strenuous as I've ever been before court, disagree. I'm not using these.
Okay, long story short, the prosecution is saying that if Mr. Williams was to get in his own statements about whatever he was saying in the video, or whether he is making a statement that he was not wearing red and therefore he's not in a gang. And we're going to hear probably the judge talk a little bit about whether that's a statement or whether it's not a statement. That's going to be a whole nother issue, whether me wearing something is a statement or not. And I do believe that it can be a statement for the purposes of the law. But the question, the issue still remains, right? If Mr. Williams wants to talk about what he intended or what he was wearing and what he wasn't wearing and what that meant, he's probably going to need to be the one to talk about it, not somebody else who's going to be attributing things either to Mr. Williams or talking about Mr. Williams, when we can just hear from the man, the myth, the leader himself, or not the leader, allegedly the leader, right? As my defense attorney people would say. So the defense attorney, if I had to guess right here, is going to disagree and say, again, he's not admitting this video to make a statement. But I do think the judge is going to disagree with that, because you're trying to make a statement that my client's not in a gang, that YG doesn't mean young gang or whatever. What do they say? RG, rich gang. I'm sorry, I'm old. Auntie's old. I don't know what this stuff means as far as gang terminology and groups. But what was I saying? Oh yeah, so that RG doesn't mean rich gang or whatever. It just means like it's our music group.
Lyrics or statements for any type of truth of matter. I am showing what I told the court. The lyrics, as everything, are not taken for truth. So 801 D2A is not a statement as a state is trying to make. They want to say any utterance by Mr. Williams is some sort of self-serving statement. That is not true. There's nothing self-serving.
It's still a statement.
That's self-serving, and it has to be
non-hearsay. It's got 801. A statement means an oral or written assertion or nonverbal conduct of a person if it's intended by the person as an assertion. So oral or written assertion is pretty broad under 801A. Mr. Steele, you can identify it. I'm telling you how I'm probably going to rule at this point in time. And if that's your desire, I'm going to tell you that I'm not going to admit it at this time, but however, that I'll reconsider it depending upon who else testifies.
So noted.
Okay, all right. Let's go.
Okay, so long story short, what did we just see there? So we just heard a really lively discussion about hearsay. What's hearsay? Is it a statement? Is the video not a statement? What does that mean? The judge read off a definition of what a statement can mean, right? It can be an oral or written assertion. It's pretty broad. Just because I don't say I'm in a gang, if I do things, if I throw up a gang sign, for example, if it is in fact a gang sign, then maybe that's an assertion or an oral assertion or a non-verbal assertion that I am in a gang, right? Because I threw up that gang sign. So similarly here, the judge is saying, well, just because Young Thug or Jeffrey Williams is not saying he's not in a gang, right? If he's wearing a shirt that's a different color from the other gang members, and he's dressed in neutral clothing, then yeah, that's an assertion. Maybe it's nonverbal, but that's an assertion that he's not in a gang. So it is a statement. And hearsay is a statement made by somebody other than the declarant, made outside of court, typically used to prove the truth of the matter thereof. And a super broad general definition is a statement made by somebody other than the declarant, so other than the person who's testifying right now, used to prove the truth of the matter thereof. That is a really super broad example of hearsay, right? So the question with hearsay is always going to be, is it for the truth of the matter asserted, right? Am I testifying? Is the person getting a hearsay objection? If I'm on the stand testifying that I was wearing a green shirt, I'm wearing a green shirt that day, I'm a green shirt girl, am I testifying to prove the truth of the matter asserted? Is the attorney putting me on stand to prove that I'm wearing a green shirt? Or is the attorney putting me on the stand just to testify that I was in the vicinity of the crime that day, right? Because I'm not testifying about whether or not I was in the crime, but if a bunch of people were wearing green shirts and I'm saying I was wearing a green shirt, maybe I was in the vicinity of the crime with the other green shirt people, whatever. That was a horrible example. But hearsay, and a really easy way to get around hearsay is you're always going to have to say it's not for the truth of the matter asserted. I remember learning that in law school, thinking I was really cool, and now I'm like, okay, that's real basic stuff. So yes, that was the issue there. So ultimately, lifestyle is not going to be admissible in court through whatever witness that was that Brian Steele was trying to get it in through. It's going to be admissible through either Jeffrey Williams or Birdman or somebody else who was in that video, but that video was not going to be admissible through that witness. But as you heard the judge say, Brian Steele, the reason that the video, that Brian Steele wants the video admitted is proper. So he wants to get it in there because to show his client's not in a gang, and that RG, whatever, doesn't stand for rich gang, or if it does stand for rich gang, it doesn't mean gang, it's just the name of the singing group. Excellent, great reasons, but you can't get it in that way. Foundation is going to be key. That's the number one thing you're always going to be having to think about, if you're going to be in trial, you're going to need to understand how you can lay the foundation. Why does this witness have context? What can they add to the case? What nexus do they have to the evidence I'm trying to get in? And if you can't lay the foundation, your evidence is not going to get into trial. Thank you for joining me. This has been a discussion about rap lyrics and the YSL trial. Don't forget to like and subscribe to the channel. It really helps the channel get boosted and get seen on the YouTube algorithm. Love you guys, and I will see you next time.